Welcome to Police Academy Prep. This is Deputy Z. Today we will be going through the Law Enforcement Basic Recruit Book of the Police Academy, going into Chapter 7, Crimes Against Persons. This will be the in-depth recording version where I read from the entire chapter and provide insight to potential test questions and real-life situations. Be sure to watch the short edition version if you are looking for a more quicker, less in-depth recap consisting of only highlighted topics. Let's go ahead and jump into the material. So before we get started here, Crimes Against Person, the chapter test, is going to be a little more of a harder test. So is Crimes Against Property, Chapter 8, because this is a lot of what we're going to do, right? Crimes Against Persons, Crimes Against Property, this is what you're going to be dealing with on a daily basis. I would expect a lot of definitions, a lot of scenarios, so just be prepared. Make sure you have a lot of study guides, using this as a study guide, reading the chapter, listening in class, taking notes, flashcards, etc. So we have 2 units in this chapter. One is Basic Investigations, and Unit 2 is Crimes Against Persons. All right, so let's jump in here. So Lesson 1, the investigative sequence. One of the most important tasks assigned to a law enforcement officer is conducting an impartial investigation to bring a suspect to justice. So anything that sounds important like that one there, expect that to be on the test. Objective investigative work is one of the main ways officers earn the public trust. Know that for the test. Objective investigative work is one of the main ways officers earn the public's trust. The quality of investigation undergoes great public scrutiny, so officers must conduct each investigation with attention to accuracy, detail, and professionalism. You establish your reputation in court and in public based upon the quality of your investigative work. When you respond to a call for service, always preserve life first and then work to preserve the scene for investigation. So know that for the test, life is first and then the crime scene. Follow basic investigative steps and use a systematic approach to each investigation. Again, a systematic approach to every investigation. Okay, scene safety. When you approach the scene of a building, do not stand directly in front of the door to avoid a fatal funnel situation. Immediately identify yourself and state the purpose of your visit. Move to and maintain a position of advantage, such as somewhere you cannot be attacked from behind. Stay out of doorways and visually assess the scene, taking note of the number of people present. All right, then we have our basic investigation flowchart here. Make sure you know this for the test. Now, you might ask, do I need to know these in order? Do I need to know the exact definitions? I would say I wouldn't spend too much time memorizing these in order, but go through it a few times where you have a general common sense idea of the flow of investigation. I would always recommend knowing the first one. So after the scene is secured, tend to any medical needs of victims, witnesses, or suspects. Then you're protecting the scene, using sensitivity when engaging with persons, determine if a crime occurred, identify and separate victims and witnesses. Do you have jurisdiction? If yes, continue. If no, refer to the proper agency. Notify your supervisor, type of crime, complexity of case, do you need assistance, etc. If a detective will respond, maintain the scene and start a log. Then you prioritize duties, interviews, evidence, documentation, arrest, or BOLO. And then top things to remember to determine and document. So that's kind of the flow. It's more or less common sense if you understand how the investigation works. So don't really need to know it for word, but little things like maintaining a scene log, when a detective's going to respond, little things like that are probably going to be in the test. Okay, here we go. Some incident scenes can be chaotic. There could be injured victims, witnesses yelling, and possible suspects on the scene with weapons. Your initial response to a call and how you approach a scene can influence the level of cooperation you receive from the victim, witnesses, and anyone on the scene. Use communication techniques to calm the situation and maintain control. Keep in mind that no 2 incidents are alike, test question, and each may require a distinct response. Once the scene is relatively calm, determine if anyone is sick, injured, or under the influence of alcohol. They may appear incoherent or may exhibit abnormal behavior. Use your first aid. All right. Make sure to remain neutral, maintain officer safety, and use verbal de-escalation techniques to diffuse any chaotic situations. Okay, so your course of action. There may be a lot of people present when you arrive at a scene. Those directly involved may not be immediately obvious. Identify who is involved through observation and answers to the following questions. Who is the victim? Are there any impartial witnesses to this crime? And does the victim have a relationship with the suspect? Understanding the role of each person involved in an incident provides a foundation for identifying the victims of a crime. Test question. Keep in mind the concept of personal space. People prone to violence or who have experienced abuse may require more personal space. All right, make sure you know what instrumentalities of the crime are. Instrumentalities of the crime are the items used by the defendant to commit a crime. Use walls or a doorway to separate and break eye contact between the people involved. This will help them focus their attention to you and can reduce the potential for verbal insults and physical threats. Understanding your responsibilities for making an arrest, whether you have jurisdiction, and whether to refer to your state attorney's office. Notify your supervisor if you are making an arrest or if you need more resources such as a crime scene technician, detectives, or medical assistance. Contact dispatch to initiate a BOLO if the suspect is not on the scene. If a detective is able to respond, provide them with any information gathered and assist them as needed. Continue to maintain the scene and start a crime scene log. Alright, let's see. Make sure you guys know the additional questions to ask. So there's a few spots in here where it says to ask these additional questions. Read through them. I wouldn't memorize them, but kind of know them because it's possible some of them will be on the test. Like it might say which one of these are a good question to ask. Make sure to provide the victim with the case number and the primary officer's name and explain the follow-up procedures. The victim may need to agree to prosecution before the suspect can be arrested. Provide the victim with appropriate brochures and document this in your report. Okay, so we're going to move to victims' rights and brochures. Victims' rights. One of your responsibilities as an officer is to interact with victims and witnesses of crimes. In some cases, being a victim is a person's first experience with the criminal or juvenile justice system. When someone is a victim of a crime, they have certain rights. So know that for the test, that in some cases, this might be their first experience with the criminal justice process. Okay, so know what Marsy's Law is, and know that it requires officers to provide all victims and their families with the following information. Victims have the right to due process and to be treated fairly and respectfully, freedom from intimidation, harassment, and abuse, accurate and timely notice of all the cases, public proceedings, including pleas, trials, and sentences, reasonable protection from the accused and any person acting on behalf of the accused, prevent the disclosure of information or records that could be used to locate or harass the victim, consult with the prosecuting attorney concerning any plea agreements, be informed of all post-conviction processes and procedures, return of property no longer needed as evidence, and full and timely restitution, proceedings free from unreasonable delay, and to be informed of their rights and may seek the help of an attorney. So for you, to really due process, freedom from intimidation, all the rest of the stuff is going to be state attorney or later through. But know that all that falls under Marsy's Law and victims' rights. The following brochures explain these rights and the services available to victims. You can find them in a variety of languages on the FDLE website. Okay, so the Florida statutes mandate distributing this information, so make sure to document in your report that you gave them to the victim. So know that the Florida statutes mandates distributing this type of information, such as a victim rights brochure. You must give crime victims a victim's rights brochure or an information card at the crime scene or during the investigation. The brochure provides the following information: the availability of crime victim compensation, crisis intervention services, the role of the victim in the criminal justice process, the stages of the criminal justice process, and the right of the victim to be informed, present, and heard during criminal justice proceedings. Victims of domestic violence must also receive a notice of legal rights and remedies for victims of domestic violence, dating violence, repeat violence, sexual violence, stalking brochure at the earliest opportunity. This brochure discusses definitions of domestic violence, sexual violence, dating violence, etc., what Florida's domestic law means, what to do if the abuser violates an injunction, the victim's information that is exempt from public inspection, and who the victim should contact for more information. Knowing the contents of each of these brochures, that shouldn't necessarily be a test question or maybe one or two. I wouldn't recommend memorizing what is inside each brochure. I would recommend memorizing each brochure, the name of them, and when you give them out. Now, when it comes to what's inside the brochure, I mean, most of it's common sense. If it talks about domestic violence, then it's obviously the domestic violence brochure. If it just talks about victims in general, then it's most likely the victims' rights brochure. Okay, then we have the victims of sexual battery must also receive a sexual battery, your rights and services brochure, and that is published by the Florida Council Against Sexual Violence. So know that sexual battery rights and services brochure is published by the Florida Council Against Sexual Violence. And that brochure contains a definition of sexual battery, the rights of victims and compensation, possible compensation for medical care, and what evidence may be collected. So make sure you guys memorize this chart here, the distribution of brochures chart. So all crime victims and witnesses should receive a victim's rights brochure and a Marsy's Law card or brochure. Well, let's start with this. All victims, no matter what, get victims' rights brochure. It's an easy way to memorize that. All victims, no matter what, get a Marcy's Law card or a brochure. Okay, so everybody gets Marcy's Law, everybody gets victims' rights right off the bat. That's the easiest way to memorize it. Now, victims and witnesses of domestic violence get notice of legal rights and remedies, and so do victims and witnesses of domestic violence that involve sexual battery. So if it's anything that's domestic, you get notice of legal rights and remedies. Okay, so everybody gets victims' rights, everyone gets Marcy's Law. Okay, domestic victims and witnesses, whether it's sexual battery or not, get notice of legal rights and remedies. But now, if it's sexual battery, whether domestic or not sexual battery, then you get the sexual battery, your rights, and services. So it's pretty self-explanatory. If it has anything to do with sexual battery, you get a sexual battery brochure. If it has anything to do with domestic, you get notice of legal rights and remedies. And then everybody else just gets both victims and Marcy's Law. Okay, you may also be legally required to transport victims and witnesses of certain crimes, such as domestic violence, sexual battery, or child abuse. Follow your agency policies and procedures. Make sure to do a vehicle check afterwards. All right, so now we're going to talk about these crimes, assault and battery. Some of the most common calls for service involve disputes and fighting. Keep that in mind. Okay, Chapter 784 of the Florida statutes outline the elements of both assault and battery. So, in regards to the question, am I going to need to know these chapters for the test? Like, Chapter 784 is assault and battery. I would say not necessarily. When I recall our tests, it was always Chapter 784 of the Florida statutes outlines this, and that, which is what? Assault, battery, burglary, robbery, whatever. You're going to have to pick the right one. So usually the chapter is in the question. It's very rarely a question of which chapter holds the elements of assault and battery. And then you have to pick 74, 75, 76. I don't recall that being the case, and in my personal opinion, I wouldn't recommend recognizing those chapters unless you have extra time to do so. And if you do, then good for you. Okay, so an assault, test question obviously, involves verbal or nonverbal threats. For example, if someone walks up to you within striking distance and suddenly raises their fist in a manner that puts you in fear of being harmed, even if they do not say a word, they commit assault. A person who commits assault commits a misdemeanor of the second degree. Now, for another question on do I need to know the degree of the charge, I would say for your big crimes, I would memorize which degree. I would say there's not a lot of questions on which degree, of misdemeanor or felony is an assault, a basic assault. That type of question is going to be rare, if any, but it doesn't hurt to memorize it anyway. Okay, for assault, you have to document that the suspect intentionally, unlawfully threatened by either word or act to do violence to a victim, and then at the time appeared to have the ability to carry out the threat, and 3, created in the mind of a victim a well-founded fear that violence was about to take place. So a lot of people confuse assault that the victim has to be in fear. That's not what it's saying here. It says the victim has to have a well-founded fear that violence was about to take place. So it doesn't say they have to have well-founded fear. It says well-founded fear that violence was about. So it's imminency. So that's where the imminency part, it has to be imminent. So they could say, yeah, I was scared, but they're a football field away screaming at you. That's not assault because there's no fear that it was about to take place, because you got to factor in the ability and also the imminency that it's going to happen right now. Now, if the guy's running at you full tilt from across the football field, then yeah, he's got a fear that's going to happen now because the guy's running towards him. So just keep that in mind. So remember, you need 3, intentionally unlawfully threaten, word or act, at the time had the ability to do so, and then the imminency, the well-founded fear that it was about to take place. For aggravated assault, know this as well for the test, document that the suspect committed all the elements of assault and made the assault with a deadly weapon without intent to kill, or with the intent to commit a felony. So aggravated assault is the same thing as assault, except deadly weapon without intent to kill. Obviously, if there's intent to kill, then that's attempted murder or something else. A weapon is a deadly weapon if someone uses or threatens to use it in a way likely to cause death or great bodily harm. So, for example, if I chuck a rock that's 8 inches at you, 8 inches wide, and it's got jagged edges, and I throw it at your head, well, really any part of your body, that's going to cause great bodily harm or death. Even if it misses, that's where it's aggravated assault. Obviously, if it hits them, then that's aggravated battery. In your report, you will need to articulate why that weapon is deadly. So you would say a rock approximately 7 inches wide by 5 inches tall. It had jagged, sharp edges, and it was heavy and made of concrete and could have caused great bodily harm or death. You would put that in your report, because you can't just say, oh, he used a rock, and it's like, well, how is a rock deadly? Because not all rocks are deadly. Even if a person points a gun at the victim with no intention of firing it, this is aggravated assault. If the victim fears the person will shoot them. A person who commits aggravated assault commits a felony of the 3rd degree. So assault is second degree misdemeanor, where aggravated assault is 3rd degree felony. All right, battery. Determine that the suspect did either of the following: actually and intentionally touched or struck the victim against their will, or intentionally caused great bodily harm to the victim. So it's or here. It has to be one or the other. So intentionally touched or struck, or caused bodily harm. So if I intentionally or actionally touch you, I'm not necessarily causing bodily harm, right? So that's why there's 2 different ways here. So just touching somebody, flicking them, throwing water at them, you didn't cause them harm, but it's still battery. And then the other part is there's battery causing bodily harm, which is obviously you actually cut skin, or you actually gave them a bruise, or actually hurt them, right? Aggravated battery includes the element of intent or knowing that you will cause great bodily harm. So if the victim is pregnant at the time of the battery, whether the suspect knew or should have known they were pregnant, this upgrades a battery charge to aggravated battery. For aggravated battery, document the suspect committed a battery and either of the following: 1, use a deadly weapon, or intentionally knowingly cause great bodily harm, permanent disability, and permanent disfigurement to the victim. For a felony battery, document that the suspect actually and intentionally touched or struck a victim against their will and caused significant injury, great bodily harm, permanent disability, or permanent disfigurement to the victim. When a suspect has 1 prior conviction for battery, aggravated battery, or felony battery and commits any second or subsequent battery, the charge is reclassified from misdemeanor battery charge to a felony battery charge. So if you arrest somebody and they have been charged twice prior for simple battery, this now simple battery that you're on with them is going to be felony battery. So if that's either felony battery when it's 2 or more, right? When they have 1 prior conviction, so it's second or subsequent. So if they have 1 prior battery and now they're committing battery again, then it is felony battery. But remember, it is conviction. It can't be adjudication withheld or not guilty. It has to be a conviction guilty charge. Now, felony battery is also battery where they cause significant injury or permanent disability. So you might say, what's the difference between aggravated battery and felony battery? So aggravated battery intentionally knowingly cause great bodily harm, permanent disfigurement of a victim, or uses a deadly weapon. So if someone uses a deadly weapon, it's aggravated battery. And then it's felony battery when you cause great bodily harm or second or subsequent. Then we have domestic battery by strangulation, which is a felony battery that is battery against a family or household member or someone with whom the victim is in a dating relationship. So right off the bat, it's domestic battery, so you know it's obviously domestic, and it's strangulation. And for it to be strangulation, don't confuse this, the abuser knowingly and intentionally impedes the victim's breathing or circulation against their will by applying pressure to the throat or neck, or by blocking the victim's nose or mouth. So if you talk to the victim and they're like, no, he had his hands around me, but I was able to breathe no problem, you wouldn't really charge with domestic battery by strangulation, because you're not impeding their breathing. If they're saying, no, I could breathe, they just had their hands around me. But if they're like, no, I was struggling to breathe, I thought I was going to pass out, then you have domestic battery by strangulation. So it doesn't say just applying pressure. It says impedes the breathing or circulation by applying pressure. So it's not just saying pressure in general, it's saying you're impeding their breathing. So that's why I said, sure, their hands are around their throat, but if they're like, yeah, because I've been on calls where they're like, no, I could breathe perfectly fine, but their hands were just around my neck. It's like, okay, well, you're just going to charge with domestic battery. But there's been plenty of times where they say, no, I thought I was going to pass out, I couldn't breathe. Then that's when you have the strangulation aspect of it. Okay, here we go. Initial focus when responding to a battery, officer safety, de-escalation, determine if a crime actually occurred, and what the suspect used. So hands, fists, feet, object, weapon, etc. Okay, let's see. You might have to do an RPO depending. So we're going to talk about reclassifications from battery or assault to a more serious event. So reclassification can occur when the victim is 65 years or older. Is a big one, right? That's elder at that point. Or an employee of a public or private school, they have to be in uniform. It can't just be, I've been at home, I've been off all week, and someone just came to my house and beat my ass. That's not... And that goes with all these people. Sports official, public transit employee, firefighter, police explorer, EMS, nurse, doctor, criminal justice officer, traffic accident investigative officer, or a security officer employed by the board of trustees of a community college. So any of these people have to be in uniform, and they have to be like on the job. I can't just be at home in my shirt, in my front yard, someone walks up and punches me. You can't just charge them with a reclassification upcharge because, oh, well, I'm an officer when I'm at work, but I'm at home chilling. That doesn't work that way. So know that list, and know they also have to be in uniform. Okay, here it is. So to reclassify the crime properly, establish that the victim was performing job duties at the time of the assault or battery, and the suspect knew or should have known the victim was one of the workers listed. All right, here we go. Okay, you may respond to an incident at a jail or correctional facility. So it has to be 5 more elements to reclassify the crime. I'm not really going to go through those. I don't remember those being on the test when it comes to... We're not in corrections, so we shouldn't have to know that. Corrections is going to handle that. Okay, warrantless arrest. Chapter 901 of the Florida Statutes allows you to make an arrest for assault without a warrant in either of the following situation. The assault occurs in your presence, the assault occurs during a domestic violence situation, or the assault occurs upon a law enforcement officer, firefighter, or EMS, public transit, or other officer. So again, you can make an arrest without a warrantless arrest when it happens in your presence, domestic violence, which obviously not in your presence, or if it's on law enforcement, public transit, nurse, firefighter, etc. Okay, the statutory chapter also allows officers to make a warrantless arrest for battery if there is probable cause to believe that a misdemeanor has been committed and that the person accused is the perpetrator of the crime. Probable cause may consist of physical evidence or sworn statements. So again, for assault specifically, it's not a misdemeanor exception, which means if two people are like, yeah, he assaulted me, but you didn't witness it, again, it says the assault has occurred in your presence, or domestic violence, which is not in your presence. So if it is domestic violence and it didn't happen, you can still make an arrest on it. Or if it was a law enforcement officer, etc., then you can still. But if it was just your Joe Schmo, 2 friends, they assaulted each other, you showed up on scene after the fact, you couldn't make an arrest on that. Unless it's battery. Okay, battery is a misdemeanor exception. All right, domestic violence. This is a big one for the test and also for real life. You'll deal with these almost on a daily basis. Chapter 741 of the Florida Statutes define domestic violence as any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of one family or household member by another family or household member. Know the definition of family or household member. It means spouses, former spouses, people related by blood or marriage, people who live together as a family or who have lived together in the past as a family, and people who are parents with a child in common. So with the exception of people who have a child in common, the family or household members must currently live or in the past live together in the same single dwelling unit. So what that means is if you have a child in common, you never had to live together. But everybody else, whether they were married, former spouses, or lived together as a family, they had to have, in the past, current, lived together in a single dwelling unit. So, for example, let's just say I have a blood brother, but he never lived in my house. Let's just say I lived with the mom, he lived with the dad, we never saw each other, we never lived together as a family. Then that would not be domestic, right? Because it says family or household members must currently live or in the past live together. In Florida, when you arrest a person during a domestic violence incident, the actual criminal charge will not be for domestic violence. Instead, the charge may be for assault, aggravated assault, battery, or aggravated battery. The relationship between the perpetrator and the victim determines if the incident is domestic violence. So again, you're not arresting them for domestic violence, you're arresting them for battery, but it's domestic violence battery. So how I like to word it, it's battery domestic, because battery, and it's just the type of battery which is domestic. It's not domestic battery, if that makes sense. The most dangerous time of a domestic violence... Oh, so that might be a test question. They might say, what is the crime here? And they might say domestic battery or this or that. If battery is an option, you choose battery, right? Is what I would go with. Or depends how they phrase it, if they want it to be domestic battery. But remember that If domestic violence is an option and then domestic battery is an option, then obviously you're going to choose domestic battery. Okay, the most dangerous time of domestic violence call is when you approach, as the abuser may know that you are coming. When you arrive, immediately consider, are there weapons? Have there been previous calls to this location? Is the incident in progress? And is the abuser on the scene? If, after thorough investigation, evidence indicates that there is probable cause that an offense occurred, and the involved persons are family or household members, arrest the abuser. Arrest, test question, is the preferred response only for the primary aggressor, not for a person who acts in a reasonable manner to protect themselves or a family member from violence. So, for example, if they give you a scenario, John walks up to Mary and slaps her in the face. Punches her in the face. Mary then slaps him and runs away. So you would arrest him. He's the primary aggressor. He hit her first. She was just defending herself to get away. And again, arrest is the preferred method. Okay, so when you're determining the abuser, you're just going to compare evidence, compare injuries, compare statements, access to communication, the location, past incidents, broken, damaged items, red flags, things like that. Dating violence. Dating violence is violence between people who have or have had a continuing and significant relationship of a romantic or intimate nature. So again, continuing and significant, romantic or intimate. Intimate being sexual. The criteria for dating violence is based on 1, a dating relationship within the past 6 months. Some people think that means it has to have been dating for 6 months. That's not what that's saying. They had to have been dating within the past 6 months. So if they're like, yeah, we broke up 7 months ago and he came over and hit me, that wouldn't be dating violence because it's not within the past 6 months. But let's just say they're like, yeah, we were dating, we broke up 2 months ago, then that's within the last. So if they say, yeah, we dated for about 2 months and that ended 2 months ago, that would still be dating violence because how long they dated is not really relevant as long as it was romantic or intimate in nature, right? And that was still within the past 6 months. It's also the character of the relationship, including the expectation of affection or sexual involvement. That's where the romantic and intimate. So expectation of affection doesn't mean sex, but that means they're holding hands, kissing, they're dating basically without the sex. Because, a lot of people can date and maybe they wait for marriage to have sex, etc. They're still in a dating relationship. Or it's sexual involvement. So I've had some people say, no, we're not dating, but she comes over here every other day and we have sex. It's like, all right, that's still dating violence. Okay, because that is a dating relationship just because they don't want to put, because I've had someone say, yeah, we just don't want to put a title on it. Okay, there's a title on it. You just don't like using the word dating. You're still dating, whether you like it or not, based off the sexual involvement. Remember, it's continuing and significant. If you're having sex with someone every other day, that is both continuing and that is significant. Sometimes they're like, yeah, we're not dating, but she spends 4 days out of the week at my place and we have sex every day. It's like, what? Okay, whatever. You know what I mean? So just keep that in mind. The decision to investigate, arrest, and charge does not require the victim's consent. You are not liable in any civil action for an arrest based on probable cause, enforcement of a court order, or service of process in good faith arising from an alleged incident of dating violence. Okay, let's see here. Okay, make sure to use children as witnesses if possible, if they were present. Try to find any evidence, physical injuries, broken furniture, etc. Physical evidence is incredibly important in a domestic violence investigation. Photograph and document evidence carefully, or document the lack of evidence. It may be necessary for you to return in 24 to 48 hours to document or collect more evidence or information. If you decide to arrest the abuser, tell the victim and the suspect why and where you are transporting the suspect. An adult suspect arrested for an act of domestic violence must remain in custody until brought before the court for a bail determination. Like dating violence, the decision to investigate, arrest, and charge does not require the victim's consent. Okay, here we go. No contact order. Know this for the test. A no contact order prohibits any oral or written communication when the victim or person named in the order, physical or violent contact with the victim, or presence within 500 feet of the victim's residence, vehicle, or workplace, or a specified place that the victim or person named in the order visits regularly. So that's what a no contact order. It's 500 feet from the person, no oral or written communication, or obviously physical. A no contact order is typically part of the pretrial release conditions imposed on someone arrested for committing a crime against another person, which would typically include incidents of domestic violence. Chapter 901 of the Florida statutes allow you to make a warrantless arrest for a violation of a known contact order if the original arrest was for an act of domestic violence. So again, that's a misdemeanor exception for a violation of injunction. Okay, injunctions. Although an injunction is a civil action, its violation has criminal consequences. Law enforcement honors injunctions from other states or countries and can advise the victim to ask the local clerk of the court to reissue the injunction in Florida if the victim is now residing here. Okay, be sure to let victims know that they can go to the courthouse and file for an injunction. All forms are free of charge from the clerk of the court. A judge will review the affidavit and then grant or deny the request. An injunction often involves custody of the victim and respondent's children. The violation of a custody arrangement outlined in an injunction will generally remain a civil matter unless the respondent violates one of the conditions given in Chapter 741. If you determine the circumstances of a child dispute are civil in nature, maintain the status quo and document the incident on the appropriate report. Okay, Chapter 901 allows you to make a warrantless arrest for a criminal act that is in violation of an injunction for protection. Victims of domestic or dating violence often hesitate to obtain an injunction for fear that the abuser may retaliate. An option for the officer may be to petition the court for a risk protection order following agency policies and procedures. All right. Okay, when you're interviewing, determine if the violent behavior is an isolated event. All right, let's see here. Circumstances surrounding... Oh, okay, so here we go. Child-to-parent domestic violence. So, child domestic battery occurs when a child commits an act of violence against a parent, sibling, or other family member living in the home. When you interview a child and family members, determine the violent behavior is an isolated event. Okay, let's see. The circumstances surrounding each child domestic battery incident are unique and require an individualized response. Refer families to the Florida Network of Youth and Family Services for local and statewide resources for emergency shelter services and individual and family counseling. Documentation. Florida law requires you to document any allegation of domestic violence with a written report. If you do not make an arrest and do not clearly write the reason why in your report, you and your agency may assume liability should the person involved re-engage in violence and injury occurs. Florida law also requires you to send a domestic violence report to your nearest local certified domestic violence center within 24 hours of receiving notification of the reporting of the incident. All right, now we're going to move on to stalking crimes. Stalking involves unwanted and repeated attention, contact, or harassment by the suspect towards the victim. So again, unwanted and repeated attention, contact, or harassment. It can easily escalate as a suspect progresses to possessive and controlling behavior. Stalking is not limited to people who have an existing relationship. Remember, you can stalk someone you don't even know. Sometimes the suspect is a stranger to the victim. It can occur as a cluster of incidents in a brief period of time or repeated over a long period of time. So generally, stalking is not one incident. It can occur at one time, but is not generally one thing. So again, it's a cluster of incidents in a brief period. So let's say this woman's being followed at the mall. She gets followed in the parking lot. She goes inside the mall, goes into a store. Someone follows her there, tries to make contact with her. She's like, leave me alone. She goes to another store. He follows her there. She tries to go to the bathroom. He tries to follow her there. Those are a cluster of incidents that could all happen within 10 minutes, right? So that's at one time, but it's multiple incidents. Or it could be repeated over a long period of time. So every Saturday, he comes over her house and screams and yells and bangs on her door. That would be repeated over a long period of time. Chapter 784 of the Florida statutes outlines the elements of stalking. Stalking occurs when the suspect willfully, maliciously, and repeatedly follows, harasses, or cyberstalks the victim. So remember, you could repeatedly follow somebody in a 10-minute period. So that's why it's saying brief cluster. Okay? Maliciously means wrongfully, intentionally, without legal justification or excuse, and with the knowledge that injury or damage will or may be caused to another person or their property. Okay, so there's no legal justification, right, or excuse. They're just doing it. That's maliciously. Stalking may not come to the attention of law enforcement if the situation has progressed to another crime, such as sexual battery, aggravated assault, or murder. Aggravated stalking occurs when the suspect willfully, maliciously, and repeatedly follows, harasses, or cyberstalks the victim and makes a credible threat. So aggravated stalking is stalking, except there's a credible threat. But here's an interesting one that you need to remember. A credible threat is a verbal or nonverbal threat or a combination of the two that place someone in reasonable fear for their safety or the safety of their family and friends. So, you get a stalking person, he leaves a note on her door that says, I'm going to kill you or I'm going to hurt you. That is a credible threat because you're putting someone in reasonable fear. It's not aggravated assault where it has to be imminent and they have to have the ability to do so. It's not like that. A credible threat is just verbal or nonverbal, and you're putting them in reasonable fear. All right, cyberstalk. Cyberstalk means to engage in a course of conduct to communicate or to cause to be communicated, directly or indirectly, of words, images, or language by or through use of electronic mail or electronic communication, directed at or pertaining to a specific person, causing substantial emotional distress to that person and serving no legitimate purpose. So again, cyberstalk, it just has to cause substantial emotional distress and serve no purpose. So if you're just annoying somebody, that's no purpose. And if it's causing that person distress. So when you're talking to a victim of cyberstalking, they can be like, yeah, he just annoys me. He just texts me every day and it's really annoying. I wouldn't arrest for cyberstalk, okay? It has to be substantial emotional distress. This person is saying they're stressed out, they can't deal with it, they're worried about their family members, I don't know what to do, I feel like he's going to come beat me up. That's emotional distress, okay? And then it has to be through cyber communication. Okay. And let's see here. Other forms of cyberstalking include cyber intimidation and sexual cyber harassment. All right, let's see if there's anything else here. Child abuse. All right, in Florida, a parent has the right to discipline their child in a reasonable manner. Corporal punishment by a parent or legal custodian for disciplinary purposes does not constitute abuse when it does not result in substantial harm to a child. So again, corporal punishment is legal in Florida. If a reasonable parent or adult would not engage in a damaging act towards a child for any valid reason, especially when the primary purpose is to cause a child unjustifiable pain or injury, the act is deemed malicious and is child abuse. So again, it has to be malicious, unjustifiable reason why, great pain and injury. For child abuse, document that the suspect knowingly and willfully abused a child younger than 18 by 1. Intentionally inflicting physical or mental injury, 2. Committing an intentional act that could reasonably be expected to result in physical or mental injury, or actively encouraging someone else to do the same. Chapter 39 of Florida statutes define physical injury as death, permanent or temporary disfigurement, or impairment of any body parts. Different types of harm can include sprain, dislocation, or cartilage damage, bone or skull fracture, brain or spinal cord damage, injury to internal organ, asphyxiation, suffocation, drowning, burns, scalding, cuts, laceration, punctures, and bites. So make sure you know what physical injury is. Make sure you also know what mental injury is. Mental injury from child abuse is an injury to the intellectual or psychological health of a child. For aggravated... For aggravated child abuse of a child younger than 18, document that the suspect committed aggravated battery. So they have to have done aggravated battery upon a child. They have to have willfully tortured a child, maliciously punished a child, willfully and unlawfully caged a child, or knowingly or willfully committed child abuse causing great bodily harm, permanent disability, or permanent disfigurement. Child neglect occurs when a caregiver fails to provide food, nutrition, clothing, shelter, medicine, and medical services essential for the well-being of a child, regardless of the age. So child neglect is just basically failing to care, right? Child neglect is more than a failure to use ordinary care. It is gross and deliberate negligence committed with disregard for the safety of the child. So if they just forgot to feed them breakfast and lunch, that's not child neglect, okay? It is gross and deliberate disregard for the safety of a child. For child neglect, document that the suspect was a caregiver for the child and willfully failed to provide the care. So if the older brother of the younger brother got left home and he was just sleeping and something crazy happened, this wouldn't be child neglect because the supposed suspect / older brother, was he actually the caregiver for the child, or the mom just left him home, right? So keep that in mind. In the context of child neglect, a caregiver means a parent, adult household member, or legal or other person who is responsible for a child's welfare who might have legal custody of a child. So again, a brother wouldn't really fall into there unless it's a adult household member. If he's 18, then that might be a different story. Know the definition of legal custody. Legal custody is a legal status created by the court The court appoints an entity, whether an agency or an individual, for example, DCF, to be a custodian or guardian. The right to have physical custody of a child and the right and duty to protect, nurture, guide, and discipline a child, or the right to provide a child with food, shelter, education, ordinary medical, dental, psychiatric, or physiological care. So those are the things that define legal custody. All right, now we have child abandonment versus surrendering a newborn. So Chapter 39 of the Florida statutes define abandonment as a situation involving a parent, legal custodian, or caregiver who, while being able, makes no significant contribution to a child's care and maintenance, or has failed to establish or maintain a substantial and positive relationship with a child, or both. A parent does not commit child abuse, neglect, or abandonment if the parent surrenders a newborn infant at a hospital, emergency room, EMS station, or fire station, or brings a newborn infant to an emergency room. So again, if they just leave the newborn infant at their house, on the side of the road, etc., that would be child abandonment. You are allowed to surrender a newborn to a place that can obviously take care of one. So hospital, emergency room, fire station, etc. Okay, so when the parent leaves a newborn infant at one of the places designated a baby safe haven and expresses an intent to leave the infant and not return, they are not exposing the child to unreasonable risk or harm, right? Because the baby will be protected. Okay, 3A3 of the Florida statutes outlines the treatment of surrendered newborns and their parents. The Florida statutes define a newborn infant, test question, as a child a licensed physician would reasonably believe to be about 7 days or younger. So that is a newborn infant, 7 days or younger. Unless there is actual or suspected child abuse or neglect, a parent has the right to remain anonymous when surrendering an infant. You may not pursue or follow a parent who surrenders a newborn infant to a designated baby safe haven. So if a mom drops off a newborn infant at a fire station and the baby's in normal infant condition, then she's basically good to go. All right, abusive head trauma. In a child, a traumatic brain injury is an injury to the head and brain of an infant or child younger than 6 years of age, usually as a result of violent shaking or blunt impact. So that's TBI, traumatic brain injury. They are less than 6 years of age, so 5 and under, and usually violent shaking or blunt impact. This type of head trauma is a sign of child abuse. Okay. Fire rescues, basically, and EMS is going to take care of the kid. All right, here we go. Contributing to the delinquency or dependency of a child. That is a crime. So for contributing to the delinquency or dependency of a child younger than 18, document that the suspect committed an act that 1. Caused, intended to cause, encourage, or contributed to a child become a delinquent or dependent child, or a child in need of services, or by act, threat, command, or persuasion, induced or endeavored to induce a child to commit or perform an act, follow a course of conduct, or live in a manner that causes or tends to cause a child to remain a delinquent or dependent child or a child in need of services. So if a mom is giving her child crack cocaine, they are causing that child to be delinquent because that kid's now going to be addicted to drugs. So that's a good example there. Okay, a person 21 years of age or older who impregnates a child under 16 years of age contributes to the delinquency of a child, even if the victim agreed to the act. So if you have 21 on a 16-year-old and the 16-year-old is pregnant, you would charge with contributing to delinquency or dependency of a child. Though your special victims unit is probably going to get involved in this type of case. Okay, responding to child abuse, neglect, or abandonment. Okay, it's emotionally difficult. Determine if there's any injuries. Sometimes you'll meet with DCF. Obviously, be careful. Officer safety. You may need to physically separate a child from the alleged abuser to prevent additional harm. Let's see. Conduct a thorough investigation. Obtain statements. Determine whether a crime has occurred and if abuse or neglect of a child occurred. If it did occur, find out who's responsible. Make sure you find a way to protect the children. Sometimes you might have to remove them. That's going to be something you do with a sergeant, possibly special victims. Okay, reporting requirements. Florida statutes require all individuals to report any suspicion or knowledge of child abuse, neglect, or abandonment by calling the DCF abuse hotline. Okay, do not place the DCF or CPI's personal identifying information, such as date of birth, home address, etc., in your report, as employees of DCF have the same confidentiality protections as law enforcement. Okay, now we have abuse, neglect, and exploitation of an elderly person or disabled adult. By the way, if you haven't had a chance to, I did release 2 videos, how to respond to elderly abuse, exploitation, and neglect, and also how to respond to child abuse and neglect. So if you get a chance, listen to those videos. They might give you more insight for the test, and also those videos were created for how to respond once you're out on the road on field training. So save those for later if you're in the academy and you want to use those for later, but feel free to listen to them now if you want a little more in-depth response type on these types of calls. All right, abuse of an elderly person or disabled adult occurs when the suspect knowingly or willfully subjects an elderly person or disabled adult to behavior that would reasonably be expected to result in the physical or psychological harm or death to the victim. The suspect intentionally inflicts physical or psychological injury, commits an intentional act that would reasonably be expected to result in physical or psychological injury, actively encourages another person to do that, or intentionally and without lawful authority isolates or restricts access to family members for any length of time that would reasonably be expected to result in physical or psychological injury or to conceal criminal activity. Aggravated abuse of an elderly person or disabled adult occurs when the suspect commits aggravated battery upon an elderly person or disabled adult, willfully tortures, maliciously punishes, or willfully and unlawfully cages a victim, or knowingly or willfully abuses the victim and causes great bodily harm, permanent disfigurement, or permanent disability. Then we get neglect of an elderly person or disabled adult occurs when the suspect willfully fails to provide the care, supervision, and services necessary to maintain the physical or mental health of an elderly person or disabled adult, or fails to make a reasonable effort to protect the victim from abuse, neglect, or exploitation by another person. The abuse may be repeated conduct or a single incident that can result in serious physical or psychological injury or a substantial risk of death. The suspect must be the caregiver for the victim. A caregiver here means a person who has been entrusted with or has assumed responsibility for the care of an elderly person or disabled adult and their property. A caregiver includes, but is not limited to, relatives, court-appointed or voluntary guardians, adult household members, neighbors, healthcare providers, and employees and volunteers of facilities, such as, daycares and etc. Okay, then we have exploitation of an elderly person or disabled adult. Adults who are elderly or disabled can be more dependent on others because of limitations and unique needs. So this places them at an increased risk of being financially exploited by friends, family, and other trusted individuals. All right, let's see here. So make sure to look beyond the surface of the situation to understand the dynamics that may be occurring when it comes to exploitation. The elderly person or disabled adult may have a fiduciary or someone who is legally responsible for managing their health and well-being or makes decisions regarding their property and finances. So know what a fiduciary means. The fiduciary may call themselves a guardian, trustee, or an agent under durable power of attorney. Do not assume that an exploitation situation is a civil matter. It is not. So if you have a daughter exploiting her grandma or elderly mom, that is still exploitation. So determine the incident shows signs of abuse, neglect, or exploitation, considering it to be ongoing, neglect, or criminal, and it's not just a family matter. So exploitation of an elderly person or disabled adult occurs when the suspect either A, takes or attempts to take a victim's property, funds, or assets, or abuses a special relationship between the victim and results in an unauthorized seizure of other qualifying social, financial, or physical hardship or neglect suffered by the victim. The elements of exploitation may appear similar to fraud or theft, but should be charged as exploitation because of the victim's vulnerability and the suspect's relationship with them. All right, let's see here. Know what an API is. That is an adult protective investigator. So DCF is for children and families, generally for children. If you're going to an adult type situation, you're going to meet with an API, an adult protective investigator. All right, let's see. An API can conduct an emergency forcible entry without a court order. So if they are going to do that, obviously let your sergeant know, and at that point it's on them to make the forced entry. So API is going to do a social services investigation where your job will be to conduct a criminal investigation. Always document the incident even if you do not find evidence of a crime. The API will also decide whether to remove the victim from the home and where to place them. All right, course of action. Let's see here. You have the Florida Elder Hotline, the Florida Senior Legal Helpline, Disability Rights Acts. Let's see here. reporting requirements like child abuse. The Florida statutes require everyone to report any suspicion or knowledge of abuse, neglect, or exploitation of vulnerable adults, disabled adults, and any elderly person by calling the DCF abuse hotline. All right, now we have lesson 6, interference with custody, luring or enticing a child, false imprisonment, and kidnapping. So first we're going to talk about interference with custody. To establish probable cause for interference with custody, document that the suspect knowingly or recklessly took or enticed or aided, abetted, hired, or otherwise procured someone else to take or entice a minor or incompetent person from the custody of the parent, guardian, public agency, or any other lawful custodian, or is the parent, whether nature or adoptive, step-parent, legal guardian, or relative who has custody, and who took a minor or incompetent person with malicious intent to deprive the other person of their right to custody. So, let's see here. The parent or guardian must have knowledge of the court order regarding custody or receive notice of the impending procedures to meet the elements. So again, for it to be interference with custody, let's just say the dad's taking the kid from the mom, they have to have knowledge that there was a court order, and they had to do it maliciously to deprive the other person of the kid, basically. So if the dad's just like, no, I'm taking my kid to Walt Disney World, and the mom isn't having it, that's not interference with custody, right? Because there has to be intent to deprive their right to custody. They're just taking them on a trip. Obviously if they're going out of state and they have no plans on coming back, they took them without the mom knowing. Obviously there's a lot of, when it comes to these types of things with custody issues, make sure you have a senior officer or deputy on scene. Make sure your sergeant's aware, because there is a lot of blurred and gray lines when it comes to this. The law does not apply to a parent fleeing with a child and who is the victim of domestic violence and believes they are about to become a victim of domestic violence, or believes that their action was necessary to preserve the child from danger. So if the mom's or if the dad's like, yo, I ran away with the kid because she smokes crack all day long and she told me that she was going to hurt the kid, then that's not that, right? It is unlawful for any person in violation of a court order to lead, take, entice, or remove a minor beyond the limits of the state, or to conceal the location of a minor with personal knowledge of the order. So this is with a court order in place. All right, let's see what we got here. Moving on to luring or enticing a child. The difference between interference with custody and luring or enticing a child is that interference with custody does not involve the intention to commit other crimes. But with luring or enticing requires a suspect to have unlawful intention to commit other crimes, such as sexual battery. So luring or enticing a child, document that the suspect is 18 years of age or older, intentionally lured or enticed or attempted to lure or entice a child younger than 12 years old into a structure, dwelling, or conveyance for other than a lawful purpose. So like they said, it's usually sexual battery. Kid has to be younger than 12. So remember that for the test, it's 11 or under. Younger than 12, because on the test they might say 12 or older, 12 or younger. Just keep that in mind. Okay, false imprisonment is often associated with domestic violence. False imprisonment, document that the suspect forcibly by threat or secretly confined, abducted, imprisoned, or restrained the victim against their will without lawful authority. So a lot of times, like they said, you will get this in domestic violence. I have charged this a bunch. For example, the female or the male, I've had both ways, is attempting to leave because they know it's escalating. They're trying to leave, or they got hit and they're like, I'm out of here. The guy or the woman blocks the doorway and does not let them leave. That would be false imprisonment. Or maybe he holds them down, right? So if she's in bed and he's trying to get away, or she's in bed, she's trying to get away, and he holds her down on the bed to not let her get away when she's trying to get away, that would be false imprisonment, because you're restraining the victim against their will. So it doesn't have to be an abduction, doesn't have to be like prison or whatever. They just confined or restrained would fit the elements. Confining a child younger than 13 years of age against their will and without the consent of their parent or legal guardian is also false imprisonment. So if this is a parent, then that wouldn't be false imprisonment. That would just be timeout, right? So a child younger than 13 years of age without the consent of their parent or legal guardian. So if it's just some random adult not letting this kid go somewhere and restraining them or not letting them out, let's just say they're in the bathroom, they're trying to get out, and this guy or girl is not letting them out, then that would be false imprisonment. All right, then we have kidnapping. The difference between false imprisonment and kidnapping is that kidnapping includes the intent to commit other felonies. False imprisonment does not require an intent to commit any crime other than confinement or restraint. Kidnapping can also involve moving the victim. So for kidnapping, if they are moving them with the intent to commit another crime, so whether it be sexual battery or, I don't know, some other crime, and that'll be kidnapping, all right? So false imprisonment is just the act of restraining, where kidnapping is restraining to then commit another crime, whether it be, sexual battery or something else. For kidnapping, document that the suspect forcibly, by threat, or secretly confined, abducted, imprisoned, or restrained the victim against their will without lawful authority, and acted with intent to do at least one of the following: hold the victim for ransom or reward, or a shield or hostage, commit or help with the commission of a felony, inflict bodily harm upon or terrorize the victim of another person, interfere with the performance of any government or political function. So you do have one version of kidnapping here that it says inflict bodily harm or terrorize the victim or another person. So you could have more than false imprisonment if they not only confine them, but then continue to beat them. That could then be kidnapping. For an incident to be kidnapping, the confinement, abduction, or imprisonment must not be slight, inconsequential, or merely incidental to the other crime committed. So kidnapping is often associated with armed robbery and sexual battery crimes. So it can't be slight or inconsequential. So it can't be like, I just stood in the doorway and you were struggling to get by. That's kind of like slight, right? It has to be like actual confinement, abduction, imprisonment, restraint, etc. Kidnapping is both a state and federal violation. Kidnapping a child younger than 13 years of age is a life felony when committed with any of the following crimes. So again, remember that 13 years of age is a life felony, and you have to commit one of the other crimes. So aggravated child abuse, sexual battery, lewd or lascivious battery, molestation, conduct or exhibition, child prostitution, exploitation of a child, or human trafficking. All right. And let's move on to missing or missing endangered persons. Okay, so same like I did with the child abuse and the elderly abuse, I did release a video for missing or missing endangered persons. So feel free to give that one a view, whether now to get extra study or for when you were getting off on field training, so that you can know how to actually respond, how to write the report, things like that are covered in that video. So give that a save for later, or give that a check out now to get more studying in. All right, a missing child is a person younger than 18 whose temporary or permanent residence is in Florida, whose location is not known, and who is reported missing to a law enforcement agency. A missing adult is the same thing, but is a person 18 or older. Okay, an endangered person is any of the following: a missing child younger than 18, a missing adult younger than 26, a missing adult older than 26 but believed to be in danger or the victim of criminal activity, a missing adult 18 years of age or older who meets criteria for Silver Alert or Purple Alert, and depending on agency policies, a person with diminished developmental or intellectual capacity regardless of age. So if they have dementia or they have autism, doesn't matter the age. Okay, missing child alert. So in real life, these Amber Alerts, missing child alerts, you're not going to do these. That's going to be a specialized unit generally, probably special victims. But for the test, unfortunately, you do need to know these. In order to issue a missing child alert, the following 4 criteria must be met. They have to be younger than 18. Law enforcement agencies' preliminary investigation must conclude that the child is in danger of serious bodily harm or death. Descriptive information or a photograph of the child must be available. The agency of jurisdiction must approve the issuance of the missing child alert. So for the test, I remember them asking a question saying that, do they need a photo? Yes, descriptive information or a photo. So either or, descriptive or photo, right? And then another test question I remember seeing was that the agency of jurisdiction must approve the missing child alert. Okay, so then you have an Amber Alert. Missing child alert may also evolve into an Amber Alert. FDLE, along with the state, local, and private partners, operates the statewide Florida Amber Alert with the purpose of publicly broadcasting critical information about an abducted child as quickly as possible via radio, television, road signs, text messages and alerts, and the internet. Okay, 5 criteria for an Amber Alert. Younger than 18, must be clear indication of abduction. So Amber Alert is more of an abduction type, where the missing alert is just missing, right? The local law enforcement agency of jurisdiction must recommend the activation and a detailed description of the child, the abductor, or the vehicle to broadcast to the public. And the law enforcement agency investigation must conclude that the child's life is in danger. Silver Alert. The statewide Silver Alert aids local law enforcement in the rescue or recovery of a missing adult who suffers from dementia, Alzheimer's, or other mental disability. So again, Silver Alert is for adults who have basically mental and developmental issues, so Alzheimer's, dementia, or some other mental disability. Under the plan, the local investigating agency activates a silver alert and notifies the media, issues neighborhood television phone alerts, and communicates with people in the public. If a missing adult uses a vehicle during the incident, law enforcement can activate the statewide dynamic messaging system and other advisory methods through the Missing Endangered Persons Information Clearinghouse, MEPIC. Know what MEPIC is? Missing Endangered Persons Information Clearinghouse, which coordinates with the Florida Department of Transportation, FDOT, and the Florida Highway Patrol, FHP, to broadcast vehicle information about the missing person to motorists and the public. So basically, they're using a vehicle, they use MEPIC, which the people that control MEPIC are FDOT and FHP. To qualify for a Florida Silver Alert, the subject must be 60 years of age or older, or a person age 18 to 59 who lacks the capacity to consent, and the person must have an irreversible deterioration or intellectual facilities that has been verified by law enforcement. So again, 60 years or older, automatically Silver Alert, but if they are an adult to 59, then they have to have some sort of intellectual or developmental disability, which is verified. Okay. The incident must also meet the criteria for FDLE, FDOT, or FHP. So, local law enforcement already activated local regional alerts. Local law enforcement must conclude that the disappearance poses a credible threat to the person's safety. There must be a description of the vehicle and a license plate. Obviously, if they're looking for a plate, or they're looking for a car, they need a plate and a description of the vehicle. Local law enforcement must verify the vehicle and license plate information, and they have to have entered the person into FCIC and issued a statewide BOLO. The Florida Department of Elder Affairs is another resource for local law enforcement to aid in the rescue or recovery of cognitively impaired missing persons. It can provide an email alert notification through the Aging Services Network. And lastly here we have, second to last, Purple Alert. A statewide Purple Alert aids local law enforcement in the rescue or recovery of a missing adult who has one of the more of the following: a mental or cognitive disability that is not Alzheimer's disease or dementia. So remember that Alzheimer's and dementia is Silver Alert, and any other mental or cognitive disability is a Purple Alert. Or if they have an intellectual or developmental disability, or another physical, mental, or emotional disability that is not related to substance misuse. So if it's a Purple Alert, can't be substance, can't be dementia or Alzheimer's. So we're talking, you know what I'm trying to say here. You know which ones I'm trying to say here. I'm just blanking hardcore right now. Local law enforcement, so like autism. There we go. So intellectual or developmental disability. Local law enforcement may broadcast an alert if the missing adult's disappearance indicates a credible threat or immediate danger of serious bodily harm to themselves, and they cannot be returned safely without law enforcement intervention. And of course, they cannot meet their criteria for Silver Alert, otherwise it would be a Silver Alert. Alright, then we have a Blue Alert. The Florida Blue Alert uses technologies employed by the Amber Alert to notify the public of critical information when a law enforcement officer has suffered serious bodily injury, is killed, or is missing while in the line of duty, and the suspect poses a serious threat to the public. In some of these cases, more information is available for broadcast, such as a description. Under the Blue Plan Alert, FDLE, Department of Highway Safety Motor Vehicles, Florida Highway Patrol, and Florida Department of Transportation immediately broadcast information about the suspect when this information could prevent further harm or help apprehend the suspect. Alright, let's see here. Additional resources. The National Center for Missing and Exploited Children, NCMEC, works with law enforcement, families, and professionals. I don't remember that one being on the test. A Child is Missing, Inc. offers free assistance to the local law enforcement to help. I don't remember that one being on the test. I do remember CART being on the test. A Child Abduction Response Team, CART, is a multi-agency team that assists law enforcement to provide an organized and planned response to an abducted, missing, or endangered child. So again, that is CART, Child Abduction Response Team. That was on the test. Rapid response is critical to the safe rescue of a child. All right. And call one of FDLE's regional operations centers to obtain CART assistance. So CART is through FDLE. Next, we have sexual offenses. All right, let's see what we got here. Sexual battery is one of the most underreported crimes because the victim may be embarrassed or may actually have a continuing relationship with the suspect. That is a test question. A victim may also feel that the suspect will take revenge if the crime is reported. All right. Sexual battery is a non-consensual oral, anal, or vaginal penetration by or in union with the sexual organ of another, or the anal or vaginal penetration of another by any object. However, it does not include an act done for medical purpose. So, again, it has to be actual penetration, either with an object or with another sexual organ, right? But it cannot be medical, obviously. Consent does not include coerced submission and does not mean that the victim failed to offer physical resistance. So, again, you cannot coerce someone into sex, and just because they didn't resist, that great, doesn't mean that it wasn't still sexual battery. Okay, the law also recognizes certain categories of people who are incapable of giving consent, and all 4 of these will be test questions. So, you cannot give consent if you are mentally defective. Mentally defective means a person who has a mental disease or disorder that renders them temporarily or permanently incapable of judging their conduct. Okay. Mentally incapacitated, a person is temporarily incapable of judging or controlling their own conduct due to the influence of narcotic, anesthetic, or intoxicating substance administered without their consent, or due to any other act committed upon them without their consent. Physically helpless is a person who is unconscious, asleep, or for any other reason physically unable to communicate unwillingness to enact. And then there is physically incapacitated, which is a person who is bodily impaired or handicapped and substantially limited in their ability to resist or flee. So just remember, the 2 mental ones are obviously mental and judgment, where the 2 physical ones are obviously physically, right? And remember that mentally defective is the lower scale, where incapacitated is the bigger scale, where helpless, physically helpless, is the lower one, and physically incapacitated is obviously the more severe one. So if you're incapacitated, you're basically unable to do anything, where if you're helpless, you just unwillingness, and they're not able to do as much. I guess is kind of how I remembered them. So the helpless and the defective ones are just the lower scale. They're asleep or they're temporary, where the incapacitated is they ain't doing shit. They're out. You know what I mean? Okay, let's see. Initial response. Okay, the crime of sexual battery of a child is a felony with varying criminal degrees depending on the following factors. So age and mental and physical capacity, type of force used, threat or use of a deadly weapon, type of injuries received, and relationship of the child to the suspect. Make sure to follow a trauma-informed approach when responding to a sexual assault. The Sexual Battery Victims Access to Services Act provides victims of sexual battery access to medical intervention, advocacy, crisis intervention, and recovery services. Okay, Chapter 794 of the Florida statutes require you to provide or arrange for transportation of victims of sexual battery to an appropriate medical facility or rape crisis center. So you are not just saying, well, have a good day, be safe. No. All right, you are required to transport the person. Know that the victim's body and clothes contain valuable evidence. Gaining that evidence is a priority for the investigation. Discourage the victim from using the restroom, showering, washing their hands or face, or discarding any clothing or feminine hygiene products. And make sure to inform them why it's so important. Let's see here. Reporting requirements. There will be a forensic report, a medical report, and a criminal report. So just remember that for the test. I believe that was a test question. Documenting sexual battery includes a forensic report, a medical report, and a criminal report. Obviously, you are going to be doing the criminal report, not the medical or the forensic. Okay, agencies must submit a sexual offense evidence kit or other DNA evidence kit for forensic testing within 30 days of receiving it. Qualified medical personnel will provide the victim's medical report, right? And the forensic people are obviously going to do the forensic report. You will do the criminal report. Then we have responding to lewd and lascivious offenses. Lewd and lascivious conduct is any sexual act considered to be highly offensive and contrary to common standards and behavior. The Florida statutes provide the following definitions related to these offenses. So, sexual activity, another for the test, means the oral, anal, or vaginal penetration by or union with the sexual organ of another, or the anal or vaginal penetration by another by any other object. However, obviously not bona fide medical purposes. Then you have the definition of consent, which is actively agreeing to do something or giving permission for something to happen. It is intelligent, knowing, and voluntarily consent. Does not include submission by coercion. Consent does not mean the failure by alleged victim to offer physical resistance to the offender. Coercion, the use of exploitation, bribes, threat of force, or intimidation to gain cooperation or compliance. Lewd and lascivious offenses may include battery, molestation, conduct, or exhibition. The level and classification of the offense varies depending on the age of the victim. Another consideration is whether the victim is a vulnerable adult. Okay, then we have unlawful sexual activity with certain minors incident. So Chapter 794 of the Florida Statutes addresses sex offenses involving a person 24 years of age or older who engages in sexual activity with a minor age 16 or 17. Notify your supervisor on this type of case. All right, so sexual offenses involving children. The Department of Justice classifies child pornography as a form of child exploitation that can be prosecuted on the federal level. The Florida statutes define child pornography as any image depicting a minor engaging in sexual conduct and includes children posing in a lewd and lascivious manner or performing a sexual act. It is illegal to produce, possess, or distribute child pornography. Okay, if you respond to this type of call, under no circumstances should you touch the device or attempt to find more images on it. Okay, let's see here. A sexual performance can include a play, motion picture, photograph, dance, or any visual representation exhibited before an audience. Be aware that many sexual offenders and predators on probation and parole cannot have any pornography in their possession and may be court ordered not to have a computer at all. Do not allow the suspect, if present, to touch the computer or electronic device. Contact your supervisor for help. Then we have sexual offenses committed by juveniles. Juvenile sexual abuse is any sexual behavior a minor engages in that occurs without the consent of the other person, without the other person being in a position of equality with the minor, or because of coercion. Juvenile sexual offender behavior ranges from non-contact sexual behavior to varying degrees of direct sexual contact. Let's see. Non-contact behavior can include making obscene phone calls, exhibitionism, voyeurism, and the showing or taking of lewd photographs. If you determine that an image was possessed by a minor or sent from a minor to other minors, this is sexting. Sexting is defined as and occurs as a crime when a minor uses a computer or other electronic device, such as a cell phone, to transmit or distribute a nude photograph or video to another minor. Sexting is a crime even if both minors consent to the act. So keep that in mind, that sexting is a crime even if they both agree to it. Except as required by agency policies and procedures and restrictions on juvenile interviewing, your investigation will be different from investigating an adult, obviously. All right, now we have human trafficking. Human trafficking is a form of modern-day slavery that involves holding people, including minors, in forced service for commercial sex trade or otherwise legitimate labor. It involves long-term ongoing captivity, exploitation, and control of victims. Chapter 787 Florida Statutes define human trafficking as transporting, soliciting, recruiting, harboring, providing, enticing, maintaining, purchasing, patronizing, procuring, or obtaining another person for the purpose of exploitation of that person. 2 threshold questions will help determine if a person is a victim of human trafficking. 1. Does the suspect recruit, transport, or hold the victim in the service of another for labor or commercial sex acts? 2. Did the suspect get or keep the victim's service through force, threats, psychological manipulation, or confiscation of legal documents? Victims of human trafficking are subjected to force, fraud, or coercion for the purpose of sexual exploitation or forced labor. Force here means physical violence that may include beatings, sexual battery, shootings, or physical confinement. Fraud includes false or deceptive offers of employment, marriage, or better life. Coercion includes use or threatening to use force, restraining, isolating, confining, lending or other credit methods as debt bondage, destroying, concealing, removing, confiscating, withholding, or possessing immigrant or identification documents, causing financial harm, enticing or luring by fraud or deceit, giving a person a controlled substance so that they can be exploited, or using threats of deportation or other federal or state legal proceedings against the victim. Neither federal nor state human trafficking laws require an element of force, fraud, or coercion to determine sex trafficking of children younger than 18 years of age or an adult believed by the person to be a child younger than 18. Okay, make sure you know how to recognize human trafficking. Living and working conditions can be unusual. Victims live near the work, overcrowded living spaces, be restricted or have controlled communications. They don't have their identification on them, etc. Okay, now we have responding to a death. I actually did a video again on responding to a natural death investigation. I am going to do all of them. I'm going to do the homicide. I'm going to do, obviously, DUI, manslaughter, vehicular homicide, murder, etc. So keep an eye out for those videos. But if you want to get ahead of the ball a little bit and listen to my natural death investigation video on how to respond while on field training or on the road on your own, give that video a view. So here we go. So manner and cause of death. The cause of death may not be immediately apparent, as some injuries may not cause a great deal of external blood loss. The cause of death is the specific injury or disease that leads to death. Okay? While observing the body, look for obvious or abnormal signs of trauma, such as the presence of blood, cuts, gashes, or bruising. Look for an obvious fatal injury, such as a bullet hole, etc., etc. Okay? The manner of death is the determination of how the injury or disease leads to death. The 5 manners of death are natural, accident, suicide, homicide, and undetermined. Homicide is the act of one human taking the life of another. Chapter 782 of the Florida Statutes has subsections that identify types of homicide, including murder, homicide, justifiable homicide, vehicular homicide, manslaughter, and DUI manslaughter. After death, a body goes through a process of changes that include rigor mortis, the stiffening of body muscles after death, lividity, the color changes from the settling of blood due to gravity, often black and blue, algor mortis, the post-mortem cooling of the body. Evidence of changes is most valuable if assessed as soon after death as possible because these indicators change over time. Make sure to notify the medical examiner, and I go over more of this in that other video I created, okay? So if it's apparent that it's natural causes or was expected, then you're generally good. The medical examiner just wants you to send a report to them. Okay, there are a few ways to identify a deceased person. Let me see. Make sure it's 100% positive ID before you release the information to the family. Let's see here. Interview. Initial investigation. Determine if you have jurisdiction. Consider the emotional response. Obviously, it's going to be chaotic and tragic. Make sure you know how to respond to an infant death. So you have your SUID, okay, your sudden unexpected infant death, SUID. Know that it is a diagnosis given only after an investigation rules out all other possible causes of death. This includes a comprehensive examination of the death scene, an autopsy, and review of the infant's medical history. Make sure the commonly reported types of SUID include SIDS, sudden infant death syndrome, accidental suffocation and strangulation in bed, and other deaths from unknown causes. Okay, now we're going to move into robbery. Okay, so Chapter 812 of Florida Statutes outline the elements of robbery. Robbery occurs when the suspect, 1, takes money or property from the victim, intends to permanently or temporarily deprive the victim of their property and takes it for their own or someone else's use, and uses force, violence, assault, or places the victim in fear during the incident. You have robbery by sudden snatching. Robbery by sudden snatching, the property must be on the victim's person, not just next to them, and the victim does not necessarily have to resist while the crime is being committed. You have to document that the suspect took money or property of some value from the victim's person, intended to permanently or temporarily deprive the victim of their property, and took it for their own or someone else's use, and in the course of the taking, the victim was or became aware of the taking. Okay, in contrast to robbery, there was no requirement that the suspect use force, violence, or threats. Okay, so robbery by sudden snatching, there's no requirement that suspect use force, violence, or threats. So keep that in mind as a difference between robbery by sudden snatching and robbery. Now we have home invasion robbery. It's often confused with burglary. A home invasion robbery occurs when a suspect enters a victim's home while the victim is present and aware that the crime is occurring. But for home invasion robbery, you have to document the suspect entered the dwelling of the victim and intended to commit robbery. While inside the dwelling, they did commit robbery. And 3, they used force, violence, assault, or placed the victim in fear during the robbery. If the suspect is armed while committing the crime, the penalty is enhanced. Now we move on to carjacking. The elements of carjacking are similar to robbery, except that the suspect took a motor vehicle. So for carjacking, document that the suspect 1. Took the motor vehicle from the victim, 2. Intended to permanently or temporarily deprive the victim of their motor vehicle and took it for their own or someone else's use, and 3. Use force, violence, assault, or place the victim in fear during the incident. All right, let's see what we got here next. All right, so canvass. Know what canvass is. A canvass is an inquiry of all possible sources of information surrounding the incident or crime scene, and it happens most often when the suspect leaves the scene. At times, you may conduct a canvass for another officer or investigator, so if you obtain vital information, relay it immediately to the lead investigator or officer. The best time to conduct a canvass is immediately after the crime or as soon as possible after it has occurred. All right, and that concludes Chapter 7, Crimes Against People. So the next one is going to be Chapter 8, Crimes Involving Property and Society, so stay tuned for that one. If you did get to the end of this chapter, congratulations. I know it's a long one, but a lot of good content, and like I said, this is going to be a big chapter for the test. There's a lot of information, and this is going to be a big deal of what you're dealing with on a daily basis while on the road. So my advice would be to actually learn this and not just learn it for the chapter test. Like, obviously, you're trying to pass. I don't blame you. But try to really learn this information because it's going to come in handy while on field training. But stay tuned. I'm going to be creating individualized videos for each type of crime and how to respond when on the road, what to look for, and how to write that report. So those are going to be very valuable videos. I already have a bunch of them out, so give those a watch early if you want, and then also when you're in field training again to get another refresher. Stay tuned for my next video. Catch you guys on the shortened version. This came out to be an hour and 20. I will create a shortened version, hopefully under 30 to 40 minutes, so stay tuned for that one. Catch you guys in the next video. Deputy Z signing off.